Hello there. Um, Thank you for joining me. My name is James. My surname is Dapperchi, and I'm a lawyer. I am a special counsel at the firm Chamberlains, and my area, the way we describe it sometimes, is sort of corporate and commercial disputes. So when business or stuff relating to assets, property, enterprises goes wrong. I'm really grateful to have your company today. And we're going to talk about a funny area of the law that is, with respect, not always perfectly understood. And hopefully we're going to shine a bit of a light on it for you. Can I start with a bit of housekeeping? Firstly, please feel free to make comments. I'm going to see them coming up in the corner here. So if you've got questions, or if you're interested in why the perspective of this seems a little bit weird and it looks like the roof is curved, or we're in the middle of the labyrinth or something like that, please feel free to post those comments or ask those questions or whatever it may be. Secondly, we're going to be recording this. So if you're joining us, or you can only be around for 15, 20 minutes or whatever it is, that's fine. We're going to make sure that the entirety of the talk, either just the audio or perhaps the video as well, is going to be available via Chamberlains, Chamberlains, the law firm I'm at, I work for. And so if you've got to step out, that's fine. If you miss anything, that's fine. Don't worry about it at all. So blah, blah, blah. That was a minute and a half, nearly 2 minutes of admin. Let's get into it. Today's discussion, I've called it Let's Get Someone Else to Sell It. And it is a discussion about statutory trustees for sale. Terence, I really appreciate that comment. Terence on YouTube has said, "You got this, Terence. Let's do it. Let's do it together." So our first question is, well, what is a statutory trustee for sale? What are we talking about here? Well, in short, what a co-owner of a property can do. So if more than one person owns a property, let's say you and I own a property, what we can do is we can apply to the court to have someone else become the new legal owner of the property, to go and sell it and to go and pay the proceeds back to us in the proportion of our ownership share. We're going to work through that as we get to it. If you don't understand it now, don't worry. You will. My job is to make sure you do, and I'm not half bad. So let's get into it. Co-owners at war. It can often seem like an intractable problem. What happens if you both own something together and you can't get along? You can't seem to decide how best to put it to use. The task is made easier of answering that question by the possibility for appointing statutory trustees for sale. And the types of people who might find themselves needing to consider this issue, there's a huge number of examples, but we can paint with broad brushstrokes and say the people who often need the court to cause new people to own their property to go and sell it are or may have formerly been married, are or may have formerly been beneficiaries of the same deceased estate, or are or may have formerly been commercial people who might have purchased land together with a view to earning some profit from it, and as time has passed, for whatever reason, that has not eventuated. So despite the best intentions of the owners, perhaps at the time they bought the property, they are not in a position to go ahead. Now, for New South Wales, and this will be a discussion that focuses on the New South Wales legislation, but there are ancillary pieces of legislation in other jurisdictions. So I don't want anyone outside the greatest state in the country to consider this somehow not relevant to their practice. These are principles that I say, with respect, are worth considering nationwide, notwithstanding that the finer points, there'll be some distinctions. All right. So 66G of the New South Wales Conveyancing Act is the section. What does it do? What actually happens if we appoint trustees for sale? Well, the order that the court makes is that a new person, so if you and I own the property, what happens is the court appoints a whole new person or people to become the owner of the property. And we are no longer owners. We become beneficiaries of a trust because that new owner is a trustee and holds that property on trust for our benefit because we're the former owners. Now, that new owner or those new owners then have a duty to go ahead and sell the property. Once they sell the property and get the money in, they then pay all the costs of that sale. And after that, they distribute whatever's left over in proportion back to you and I as the former owners of the property. Does that make sense? We are legal owners. We transform into beneficiaries of a trust. A new trustee comes in, sells the property, pays some money where she, he, it, or they need to pay it, and then gives the rest back to us in the proportion of our ownership after taking out their fees as well. So there's some complexity to the process. And so long as we're in this introductory phase, let me talk about how we're going to attack it today. Today's talk is divided into 3 sections, and this is often how I think about things. So if you're ever joining me for a cup of tea or joining me for lunch and have a bit of a CLE, you'll find this is the way my brain works when I think about these areas. But we'll be talking in 3 different sections today. Firstly, we'll talk about the law relating to the appointment of trustees for sale. The next thing we'll do is we'll work through some practical examples. And then after that, we will come to some nuts and bolts suggestions for things that you can do when you're on the tools if these things pop up. Now, through the talk, I'm going to have a sip of tea from time to time. Through the talk, I'm going to read your comments. So if there's anything you'd like to say or any questions you'd like to ask, please go ahead. And through the talk, we're going to have a little bit of fun as well because it's an interesting area that I hope assists you as we work through it. Mina, what a lovely comment. Thank you. Hope your day is going well. And James Wrigley, the king of going live. It's very lovely to have your company as well. Okay, let's move into the first section of this talk, which we're just going to broadly call the law. This is going to be the hard bit. This is going to be the technical bit. This is going to be the crunchy bit. So strap yourself in. We're going to dive deep for about 10 or 15 minutes. Don't worry, on the other side of that, we're going to come out and talk about some examples that are going to help us understand the law even better. So let's talk about the law. And let's repeat ourselves to an extent, but elaborate somewhat. What actually happens if the court makes an order pursuant to Section 66G? Well, what we lawyers call legal ownership, which speaking roughly might be ownership so far as external parties such as financial institutions or such as land registry services or something like that might perceive to be the owner. So legal ownership, the sort of recorded technical ownership will pass to new legal owners. So while you and I are today, we are legal owners, but tomorrow 66G orders are made, then tomorrow new legal owners will arise, and those new legal owners will hold the property on trust for your and my benefit. And we, as I've said before, but I'd like to have settled in your head, and don't worry if this hasn't quite made sense yet, it's going to, I promise. We change our interest from being legal owners. So Land Registry Services no longer thinks we're the owner. It now thinks Julie and Jane Bloggs, the trustees for sale, are the owners. And we have become beneficiaries of a trust for sale. Julie and Jane have to go and sell the property, pay out the proceeds, pay out the costs, and then return the proceeds back to us, because that's the way that the sale trust works. Tinash, thank you for your comments. These are situations you bump into in your practice. Look, it would be great if I can bring some value to you as we work through it. It's a very kind comment, and I appreciate it. Okay, you'll be pleased to hear we're not going to read through the section in full. We're not going to go through the legislation verbatim. I'm just going to extract a couple of relevant points from Section 66G of the Conveyancing Act as we go. Now, importantly, 66G applies to land. It does not apply to chattels. It doesn't apply to things, right? So the appointment of trustees under this particular section is land only, and in addition to that, Section 36A of the Conveyancing Act, if we're in New South Wales, allows for the appointment of trustees in respect of chattels. So it's just a different section you're looking at. It operates slightly differently, as you can imagine, but the fact that 66G doesn't apply to chattels is not fatal. It's just something that needs your attention when you are thinking about how these things work. Now, if 66G proceedings are commenced and the owners are joint owners, remember what normally happens if owners are joint owners and someone dies? So if you and I are joint owners and I die, you automatically become the 100% owner, right? But remember that if you and I are tenants in common, 50-50 owners, and I die, well, you stay a 50-50 owner, and the other 50%, my share, comes into my estate to be distributed pursuant to my will or pursuant to the intestacy rules or whatever it may be. Does that make sense? It's called the right of survivorship. So joint owners, someone dies, the entire ownership resides in the surviving owner. Now, what happens if you and I are joint owners, but during my life, we've commenced 66G proceedings that are yet to be finalised? Well, legally, it's not quite a conversion into tenants in common, but it is similar. The right of survivorship does not operate if Section 66G proceedings have been commenced. So let's run through that scenario once more because it's important for us to understand. You and I are joint owners. Normally, if I die, you own the whole thing. You and I are joint owners and you've commenced 66G proceedings and I die, then your interest in the 66G proceedings stays yours, and my interest in the outcome of the 66G application falls into my estate. So it's almost like, it's not the same, but it's almost like our joint ownership has been converted into an interest as 50-50 tenants in common. It's not the same, but there's an analogy there from the perspective of the right of survivorship. Who can be trustee? Well, you can have one corporation alone, or you can have somewhere between 2 or 4 natural persons, and you can also talk about combos there. But you can't have just one natural person being a trustee. A couple of other technical points that we don't need to linger on too long because I'm conscious of your time. I'm going to try to give you an early mark today because I think if you stay the distance and I drag you till 2 p.m, then there's a degree of heartbreak there. I reckon I can get us out by 1:45, 1:50, something like that. Let's see how we go. If the application in relation to a trust for sale is opposed on the basis that it ought to instead be a partition order, then there is scope, depending on a notice process, for the court to consider that. So rather than sell the whole thing, there's scope for the court to partition it. And why don't I turn put my phone on silent when I'm giving a seminar? That's probably a pretty good idea. Sorry about that. Let's see if it's important. Certainly not more important than this, but you know, we all want to make sure that we're keeping up with what our clients need and what our obligations are. That's fine. No need for you to think about it again. I'll attend to it after this talk. Okay. What I hope you'll find from that quick chat about 66G is that the apparent simplicity of saying, oh, I used to be the owner, you and I used to be the owner, now we've got a new owner, they got to sell it and give the money to us, can seem quite simple on its face. But as we work through some of that law, what I expect you found, and what I find whenever I sort of turn my mind properly to it, is that there's a little more complexity there than it can initially appear on the surface. Okay. Chief Justice Ward, Her Honour in 2018, gave what I consider to be, with respect, a very useful summation of some of the relevant elements that relate to 66G, the appointment of trustees for sale. And we're going to spend a moment after I have a sip of tea working through those. The broad point is that although there is a discretion in relation to the court's ability to appoint trustees for sale. The appointment of trustees for sale will be made almost 100% of the time. Or to use a different phrase, it's an appointment that is made almost as of right. And so what we find is that if someone wants a 66G order, if someone wants trustees for sale, they, with respect, are supremely likely to get that order made. And so what we find then is that there is a discretion, but there's no general jurisdiction to refuse an order on the basis that someone might have been done a hardship or it might have been difficult for someone. And there's no real reason to stand in the way of a 66G order being made, aside from maybe fiduciary obligations, contractual obligations, or proprietary rights standing in the way. So if you want a 66G order, you'll probably get one. And if you're trying to oppose one, well, you might have a tough time doing that. In relation to the costs of a 66G application, if neither party has acted unreasonably, then the legal costs, so I'm pouring myself some more tea, then the legal costs relating to the appointment of the trustees, relating to that piece of litigation where they're appointed, those legal costs will become costs payable from the proceeds of sale. So the money that the trustees get in from selling the property, some of that money can be used to pay the legal costs. So it'll work out all right. Now, and sorry, that's the usual position, and it can be upset, as you might recall, as I hope I made a little bit clear. That usual position can be upset by the beneficiaries behaving in a manner that is not reasonable. Okay. Just a couple of little other legal bits to pick through, and we're getting close to finishing up the legal stuff. I've only got about a page more of legal stuff to go before we get to some examples. So you're all doing very, very well, and you are seconds away, or perhaps about 240 or 300 seconds away from a well-deserved pat on the back. 66H of the Conveyancing Act grants an obligation on the part of the trustees, as far as practically possible, for the trustees to consult with the beneficiaries of the trust. So there is an obligation for those new legal owners to speak with the former legal owners, the beneficiaries of the trust, about the nature of it, the operation of it, and the way they think it ought to be discharged. Now, just to be clear, that obligation is an obligation to consult, and I might add the word only. It is an obligation to consult only. So the trustees are not bound by what the beneficiaries might want, and there's no reason to suggest that the trustees might take complete comfort either necessarily from the comments made by beneficiaries pursuant to section 66H. 66I provides the opportunity for the former owners, who are now the beneficiaries of the sale trust, to purchase the property or part of it, potentially by way of set off. So if there's a property worth 10 million bucks, one of the beneficiaries wants to buy it, then in certain circumstances, the 5 million bucks that beneficiary might hope to receive, depending on the costs that are incurred, which is another point we'll come to later, that amount can be set off as against the purchase price that the beneficiary contemplates paying in purchasing the property. And then real quick, in relation to who is going to become the trustee, what criteria will the court engage in deciding who's the appropriate person or people to become the new trustees, which is to say, become the new legal owners of the property? Well, the court is going to tend to prefer the preference of whatever party has the higher interest in the land. So whatever party owns more, owns a greater share, they'll have quite a weighty say in expressing their view for which trustees they like. Trustees should be as independent and free from conflicts as we can make them. The trustees, look, especially if the sale is going to extend beyond a pretty simple conveyance, telling a conveyancer to go sell some property and pay the money, they should be as skilled. They should have the appropriate skill, expertise, and experience. And the court should also try to get the best value for the party's money. So it's going to be relevant if you have competing sets of trustees for you to say, look, they're independent, they are skilled and experienced, and they're only going to cost X. And what you often see is that there can be a war of contemplated expenses between the trustees that each party seeks to press for. And in those cases where there is competition, the broad position is the court will try to prefer the cheaper options. Okay. As we said, this talk's divided into 3 sections. We started off with the law and you just got through it. So you've earned that pat on the back. Congratulations. We are now going to move to a discussion of a number of decided examples. And the reason for that, and if you've been following a lot of these talks, joining me at lunchtimes in previous weeks, is because what I say is that there is some complexity to the law, and that our understanding of that complexity can be amplified or improved or refined by working through some decided examples. And so that's what we're going to do now. Before we dive into it, I'm going to return to a bit of housekeeping. Now, this is being recorded, and so if you missed some or if you need to duck out or anything like that, that's fine. Firstly, this is automatically being recorded up on YouTube, so I've got a YouTube channel called Coffee and a Case Note. You can head there and check it out. Secondly, the law firm that I'm at, that I work for, Chamberlains, is going to be uploading this at some stage later. So if you have just joined us or if you're worried about missing something, chamberlains.com.au will be the place to go, or indeed whatever podcast provider you use, go have a look for Chamberlains there and you'll see that we're putting up stuff of value all the time. Okay, let's dive into some of these examples. Let's dive into a question about when can the trustees for sale keep some of the money? It's a difficult one. This is a decision called O'Day and O'Day. It's a 2019 New South Wales Supreme Court decision. We've got a pair of brothers, and these brothers are 50-50 tenants in common of a block of units in Bondi. And one brother commences 66G proceedings. And as you know well, if someone commences 66G proceedings, they're pretty likely to succeed. And so that brother does succeed, and 66G trustees are appointed. Okay. Those trustees then start going about their work and having a think about how best to sell the property. And the first contract for sale they enter into is with the defendant, who is one of the brothers. And they agree on a price of about 6.3 million. And there's a bit of argy-bargy, there's a bit of back and forth. A notice to complete is issued, but in short, the sale to the defendant brother doesn't go through. And so that conveyance fails. Later in 2019, there's a sale to an unrelated party for 5.8 million. So a little bit of a reduction on that 6.3 position. Well, the trustees paid out various costs and disbursements and then are sitting on this chunk of cash, having now sold the property. And what the plaintiff says, the good brother, and when I say the plaintiff himself actually died before these proceedings were finalised. So it's his estate, it's his interests that I'm referring to, but I'll use the shorthand of referring to the plaintiff as we go through. The plaintiff saying, well, now hang on, my brother over here caused this sale to fail. And all these trustees' fees have been incurred on relation to that. That shouldn't be visited on me. That was his fault. His entitlement should be adjusted down, and so mine adjusted up from the proceeds of this sale. Now, court said no. The reason the court said no is that if the court was to agree to a summary adjustment, that would more or less be a complete outcome of that claim without having had the opportunity to properly hear all the evidence and cross-examine parties and that sort of thing. Further, the court said that claim was not a claim between the two brothers as co-owners. It was a claim that the trustees had against the brother. It wasn't a claim of the other brother. And so it wasn't actually the plaintiff brother's claim to put forward and prosecute. And there was another point raised where the trustees sought the judicial advice of the court about hanging on to some money. And the reason they sought this judicial advice was because the defendant brother had flagged some vague claim that he might wish to bring in future, but hadn't really particularized it. And so what the trustees said is, look, there's this potential claim hanging in the air. We don't know what it is. Court, can we please hang on to a certain sum of money in relation to the fees and costs that might be incurred in relation to defending that claim? And there were some calculations done and some estimates given, and the court said yes, in short. And so what we have is our dead brother, if I can say that way, our plaintiff a bit disappointed that his entitlement is not adjusted up because of the defendant brother's failed sale. And we have the trustees hanging on to some money on account of a potential future argument with the defendant brother. And as I meant to say earlier, what we're going to find as we work through these examples is because, as we learned, there's not a whole heap of controversy about will or won't a 66G order be made. Often what we're speaking about are what might be thought of as satellite issues that sort of are around the appointment of a 66G trustee, but aren't directly targeted at the question of will one be appointed or not. So previously, for example, the trustees had already been appointed at the time the dispute was on foot. And so let's have a look now at the question of when will a 66G application fail? Well, as we mentioned a moment ago, rarely a 66G application is likely to succeed. And so when will it be the case that that won't happen? We're going to turn to a decision called Sakar and Sakar, which is a 2019 decision of the Supreme Court of New South Wales. We've got a mother and father who are owners of a property, and we have a son who is the mortgagee in respect of a mortgage taken out on mum's share, right? So we've got mum and dad are co-owners. We've got son who loans mum some money, and that loan is secured by way of mortgage. Now, the evidence in relation to the fact of this mortgage, the basis of this transaction, were a little bit cloudy, and it wasn't perfectly clear. And both mother and son were found to be witnesses with some pretty serious credibility problems. So the court had a number of issues to confront on this one. The mother had executed the loan in the company of a lawyer, and that included a certification in relation to having received independent legal advice. And with apologies, I'm keeping my eyes on the comments here. Nick, you're welcome. Thanks for taking the time to join in and taking the time to comment. Now, that mortgage was then registered, and the son had the benefit of that security. Now, when pressed, our son was unable to really identify any benefits that mum took from entering into that transaction. And then to give you a bit more context, what mum also was in a relationship with the son where there was a strange power imbalance between them. Now, son was a lawyer, and son was accustomed to getting what he wanted in this household and to giving directions to his mum. But there was also a power imbalance the other way around where mum had quite a firm hand in the relationship as well at various times. But what the court found was that the influential position that son had in respect of mum meant that the pressure he applied to mum in entering into that mortgage was unfair, and that meant the agreements were unfair, and that unfairness pursuant to the relevant legislation meant that the agreements were void. Now we're talking about section 66G. The son has a right as mortgagee to seek 66G orders, but remember what we just found was that that mortgage was void, and so what we find is that the son has no right to 66G orders, and so we have the example of a 66G application failing. And so if we wind back to our question, when will a 66G application fail? The answer is, as seen in this case, when there is no entitlement to an order. And in this case, we found because of the mortgage agreements being made void, there was no entitlement on the part of the son. All right, let's have a think about this legal costs point. Because if you'll remember, if the parties both behave reasonably, then as we've learned, the legal costs of those parties are going to be paid from the corpus. They're going to be paid from the proceeds of the sale trust. But let's have a think about what happened in this scenario. This is a decision called Lisi and Fono. Now, we've got an argument again in relation to co-owned land, which is our scenario today. And there's a bit of back and forth, a bit of argy-bargy, but before final hearing, the parties agree that 66G trustees should be appointed. The only thing they don't agree on is who's paying the legal costs. And just to turn to the comments, Mina, thank you for that farewell. Delighted to hear that you'll be going over this material again. Hope it brings you value. And thanks to everyone for commenting. It's very kind of you to leave a comment, and reading these is very nice. But so our parties agree that trustees should be appointed, but they argue about legal costs. And what the plaintiffs say is, look, our legal costs should be paid from the sale trust, but the defendants shouldn't, because the defendants unreasonably refused to agree to appoint 66G trustees before, and because they behaved unreasonably, they shouldn't get their costs. Now, what the defendants said was each party should pay their own costs because the plaintiffs didn't negotiate on a sale process and the proceedings were conducted in a wasteful way. Now, what the court went and considered was that the plaintiff's evidence in support of the 66G application was lengthy, and it ventilated all these disputes between the plaintiff and defendant. Oh, you've done this wrong, and lots of pages and lots of material for the court to go through. And so lots of legal costs incurred in relation to the preparation of this evidence. Now, the actual position was that the plaintiff didn't really press any of the complaints in that evidence, didn't seek to adjust any entitlements between the parties, and so the incurring of legal costs in relation to all that argumentative evidence was unreasonable in the circumstances, which meant that each party had to bear their own costs of the proceedings rather than each party being reimbursed from the trust funds. And so the plaintiffs who'd incurred, one assumes, a lot of legal costs, had to go pay their own. And then the defendants who had incurred, one assumes, and one can assume, less, were left to bear their own as well. But that weight was lighter on the defendants than it was perhaps on the plaintiffs. Okay, well, so long as we're on the topic of legal costs, let's have a think about when it's appropriate that an indemnity costs order might be made in relation to a 66G application. Now, normally, as we know, the parties' legal costs are going to be paid from the net proceeds of the sale of the property. Trustees are going to sell it, they're going to get the money in, and before distributing out to the beneficiaries, legal costs will be paid from it. Well, let's dive into another mother-son dispute and see how we feel about that. Plaintiff mum seeks the appointment of 66G trustees, and initially the son is very resistant. Eventually, over time, the son agrees to the making of orders, the only other issue being legal costs. Now, what mum, or I should say, mum has appointed a financial manager, which, as many of you know, is very, very similar to sort of an attorney, or in these circumstances, a tutor, someone who can make binding legal decisions on behalf of someone else. And we can get into what a tutor is in time. But for the moment, mum has a tutor, so there's someone else acting on her behalf, making decisions for her. Now, what the financial manager does is, upon being appointed, seeks to sell the property. And the defendant resists, including making an application to the NCAT to review the final manager's decision. And that's what you want to do. And that's what you do if you're trying to challenge a financial manager. But eventually, the plaintiff's financial manager moves to sell the property because the defendant is unable to convince NCAT that it's improper that the property be sold. But the defendant continues to resist. And he resists on the basis that we can find funds from elsewhere. Don't sell this property. Well, the defendant provides no evidence of where this other funding is going to come from. And so the plaintiff, mum, as I said earlier, is forced to bring her 66G application. Now, don't forget, financial manager firstly resolved to sell the property, son stood in the way. Secondly, resolved to sell the property, and then son brought NCAT proceedings. Thirdly, resolved to sell the property, and now we're in 66G proceedings. And as we learnt before, son agrees to the 66G application, and the only issue is this cost dispute. Now, what the court found is that the defendant's conduct, the son's conduct in applying for this NCAT review and failing to give any evidence of alternative funding was unreasonable because he sort of stands in the way, resists, and then eventually relents, and that's found to be unreasonable. And so the plaintiff, by her financial manager, is forced to bring the 66G application due to that unreasonableness. And so the costs that mum has incurred in relation to that application can be seen as arising from the unreasonable behaviour. And so on that basis, an order for indemnity costs, solicitor client costs on that higher basis than ordinary costs, is made in favour of mum and against the son. Okay, got a couple of decisions to go. I think I flagged an early mark at 145, which is not looking good. Let's revise that early mark to maybe 150 and see how we go. I'll be able to dispose of this next one fairly quickly. We're still in legal costs land, and I think, or I hope, what we're learning here is that the issues or the pieces of litigation revolving around a 66G appointment are not in the vein of will they, won't they appoint a 66G trustee. They are in the vein of sort of what we might call satellite litigation, disputes between the parties about what should happen after the 66G trustees have been appointed. Now, our plaintiff is a bankruptcy trustee, and the bankrupt estate includes some real property. There's some back and forth about a sale, but the plaintiff commences 66G proceedings, and you know what happens when someone commences 66G proceedings. They almost certainly succeed. They almost certainly get trustees for sale appointed, and indeed that is what happened in this scenario. Now, the orders made included an order that the defendant co-owner pay the plaintiff, the bankruptcy trustee, pay the plaintiff's legal costs. So the property gets sold, and the plaintiff's lawyer sends out a bill saying, oh yeah, thanks for agreeing to pay the costs. Here's the bill. Go ahead and pay it. And the co-owner's solicitor has to chase and chase and chase and chase. And to put it politely, the other co-owner is resistant and non-responsive. And so normally what happens if you're not getting your costs paid, is that you need to turn to, again, speaking broadly and briefly, you need to turn to this idea of cost assessment. Costs are sent off to an assessor, and it's a process that, with the greatest of respect, is not known for its speed. And in this case, the bankruptcy trustee was able to say, can we avoid cost assessment, and can I get just these fixed sum costs ordered? And the short point was yes. So another cost dispute arising out of a 66G appointment. Quickly, Grosh and Knights. This is a decision of the Supreme Court of New South Wales, 1365, 2018. Now, I'm going to try to get through it reasonably promptly if I can. We've got two co-owners of property in New South Wales. One of those co-owners moves to Victoria, and one of those co-owners moves to jail. And the co-owner who moved to Victoria sought 66G orders in relation to the land and 36A orders in relation to some of the chattels on the land. Now, the evidence isn't perfectly clear, but we've got this on-again, off-again relationship. And our applicant, our Victorian co-owner, puts on evidence saying, look, I've made all these mortgage repayments, and so my entitlement from the trust should be adjusted up, and the imprisoned co-owner's entitlement should be adjusted down. And the imprisoned co-owner says, wait. No, I lived on the property and I made all these improvements. And so my entitlement should be adjusted up and yours should be adjusted down. And so we have this difficulty where there's no evidence to suggest that any of these, there are suggestions made about blackmail and impropriety, and there's no evidence of that. But the court hadn't really reached a conclusion about the proper outcome of both parties seeking more or the other party to be reduced and them to be increased in relation to the outcome of this trust. And partly that's due to the fact that the evidence is not in a great state. Partly that's due to the fact that the judge has difficulty running the hearing via video link, although the idea of video link being a problem for running hearings might just at the moment sound a little bit strange. Part of the problem is that the evidence from the Victorian co-owner is not in great shape either, and she indeed was not called to be cross-examined on it. And so what the court says is that, look, in circumstances where we've got this claim from the defendant saying there have been improvements made, saying that, and then the Victorian co-owner saying, look, he's lived there rent-free for so long, I've made all these extra mortgage repayments, and I've made all these extra payments of rates. The court said, look, the evidence here is not sufficient for us to sit down and form a view. So what we're going to do is we're going to appoint the trustee today, and we're going to kick the can down the road with respect in relation to the argument about allowances, increases, decreases to another day. And that is indeed what the court did. Now, the final case we're going to look at, I need to make a disclosure. That disclosure is that I acted for the trustees for sale after their appointment in these proceedings. So I was not involved in these proceedings, but I subsequently acted for the trustees who were appointed. So that's just by way of disclosure. I don't have an actual role in this piece of litigation we're talking about. So a dispute arises between three brothers, and the dispute might be described in short as being about the proceeds of Mum's estate. Mum is reasonably wealthy, and her estate includes jewellery of considerable value, and it includes some real property of very considerable value. And in the end, the value exceeds about $20 or $30 million, as I recall it. But the real question is that in circumstances where the brothers put forward competing trustees for sale, the court had to dive in and think, well, okay, to deal with this trust for the sale of diamonds, trust for the sale of property. And the court had to work through these sort of competing pairs of experts. Now, one pair might be described as property experts, They were very experienced at very big real property firms and consultancies, and they knew a lot about property, buying it and selling it. And the other experts might be thought of as insolvency practitioners. They were experienced at being external administrators of stuff. And so they might say, yep, make us the external administrator of this real property and these diamonds because we're good at external administration. And the property experts, we might say, would say, make us the external administrators, the trustees for sale of this stuff, because we're good at that. And the court said, look, there's sort of an apples and oranges degree of this. Both trustees are sufficiently independent, so independence is not an issue. What the court did was to work through the actual specific skill and expertise. And they spent some time thinking about, yeah, okay, there's the skill and expertise of our insolvency practitioners. They know what they're doing when someone else used to own something and they are now the new owners. And then we've got our property experts and they know everything there is to know about property. And what the court did in a finely balanced decision that, with respect, may have gone a different way on a different day, and as I say that with the greatest of respect, was the court finally came down in favour of the property experts who were eventually appointed. And so what I say is that that decision stands as a useful insight into the possibility that expertise, aside from being an insolvency practitioner, can be relevant if you are looking to get appointed as a 66G trustee for sale. And it's confirmation that chattels, not just real property, but things, in this case diamonds, can form the subject of a statutory trust. So, as we said before, today's talk is divided into 3 bits. We had our big, ugly law, technical, crunchy stuff. We did that. Well done. Then we worked through a lot of examples that I hope helped you sort of come to grips with some of the crunchy law stuff. Now I'm just going to make a couple of quick suggestions and then I'm going to get out of your face. If anyone is just joining us or if you've missed anything, don't worry. This is immediately going to be available up on YouTube on my account, Coffee and a Case Note. But more interestingly and more efficiently, we might say, my firm Chamberlains is going to turn this into a podcast and turn this into some other things. So if you keep an eye out for Chamberlains, Chamberlains.com.au is the website, but you'll be able to find us on socials and find us on your podcast provider as well. So practically, if we think about 66G, what we might do is compare it to other pieces of commercial litigation and say, well, it's actually pretty cheap. The court's almost always going to make the orders. Legal costs are going to come out of the sale proceeds if everyone's going to be reasonable about it. And so, look, that's fine. And what I would also, what I would add to that is, yes, maybe, but I think what we've learned today is a number of different things. One of those things is the possibility for what I'll call satellite litigation. So after the trustees for sale are appointed, there are these other little sparks that can fly up, other little issues that the parties have to litigate or end up litigating between themselves, chasing legal costs, and arguing about the trustees hanging onto some money because someone else might make a claim and failed sales and all this sort of stuff that we've been working through. So the idea that appointing the trustees is easy is, with respect, right, but, or perhaps and, in addition to that, there is going to be complexity in relation to these pieces of satellite litigation that I say are going to flare up and deserve your time and attention. So, put another way, 66G should be seen as useful, but not necessarily a quick and cheap fix because of these other pieces of satellite litigation that might prop up. In addition to that, and with the greatest of respect, sometimes the fees of trustees for sale can be such that they might end up being disproportionate. And so that is another matter for you to bear in mind if you are reflecting on whether it's a good path for your clients to be going down in relation to dealing with their issues. The best outcome is not to litigate, is to agree. And I say that as a litigator. So it's not necessarily in my interests to say that. A couple more practical suggestions, then I'm going to turn to some comments and some questions here. So if you've got any comments or questions, please feel free to plug those in. Some other matters that I say that the appointment of a trustee for sale might actually be a more surgical way of dealing with some kinds of disputes. So if we take for the example of, let's say, a partnership dispute, where sometimes you might look to appoint a receiver manager to some of the partnership assets, there can be some real fiddly complexity to that. What I say is there is an open question as to whether the better, and I'll say better in, in a very loose way, the better approach might be to consider the appointment of a trustee for sale, come in, sell the thing, get the money, get out. That's one question. And the other practical suggestion is the consideration that while insolvency practitioners ought to be your first thought when you're thinking about a 66G trustee for sale, there can be circumstances where, as we learned in the matter of Chow, there could be appropriate times where property experts or some other relevant expert might be brought in. And so that brings me to the conclusion of today's chat. So we talked about the law, and we learned that 66G or that trustees for sale, depending on your jurisdiction, is all about people who are currently legal owners getting someone new appointed to become the new legal owner, and those former legal owners are over here and become beneficiaries. And so the new legal owner's got to sell the property, get the money in, pay out the costs, pay it off to those beneficiaries. What we learned in our examples, I say, is that while it can be quite easy to get a 66G trustee appointed, there can also be some factual complexities that flow from it, and indeed legal complexities, little bits of what I referred to earlier as satellite litigation can flare up, and it's worth, with respect, being worried about that. And finally, I made some practical suggestions that I hope were of value to you. Thank you for your time. A couple of lovely comments here. Mina asks, are you feeling okay? And then says, thank you. Mina, you're very, very welcome. Yes, I'm feeling okay. I'm sorry that I don't. Sometimes my voice sounds like I might have a cold. Today might be one of those days. Mina, I'm grateful for your concern. Lucy, I'm grateful for the shout out to Nigel just there. And to all of you who've spent some time with me today, I'm really grateful for your time, for your company. And unless there are any other questions, I'm going to end it there. My thanks to you all, and look forward to speaking again this time next week, Tuesday, 1 p.m. We're going to pick a different topic. And if you got value from today, there's every chance that you get value from next week. And look, it would bring me great pleasure to have your company then. For the moment, thanks so much.